Hi guys, video today. I'm going to be looking at two Supreme Court cases, Marbury v. Madison and McCulloch v. Maryland. We're going to do it in 5 minutes because that's all the time I have on Screencastify free version is 5 minutes. So I got to get to it. Hope everyone's doing all right. So first case, Marbury v. Madison. This is the first major case in Supreme Court history, and this is the case you all should know that gives the Supreme Court the power of, you said it, judicial review. So, to midnight judges, John Adams appointed midnight judges, the final days of his presidency. Republicans don't like it. The central case is, should William Marbury be given his appointment that was not finished by John Adams? Now, this could have been a very simple case where Marbury or John Marshall, the great Chief Justice, best justice of all time, where John Marshall could have said, yep, give him his appointment, get it done. But John Marshall made this a much more important case because he made it a case about judicial review. So the question is, he made this constitutional question. You'll see this on the slide, CQ, constitutional question. Is the Judiciary Act of 1789 constitutional? And that was the act that gave the courts the power to issue a writ of mandamus, which would force Madison to deliver the appointment. So John Marshall said, look, I'd love to give you the appointment, William Marbury. You should get the appointment, but we don't have the power to do so because the Judiciary Act of 1789 is unconstitutional. So first time ever, Supreme Court declares a law unconstitutional. The Supreme Court gets the power of judicial review. So John Marshall's brilliance is shown here. By saying the court doesn't have the power to do something, he actually is giving a huge power to the Supreme Court, which is the power of judicial review, to declare laws unconstitutional. And that is a huge power we still recognize today. And it's why it's a part of all these foundation cases we'll look at. So it's really, really important. So judicial review, Marbury v. Madison. And there's a whole bunch of other things here if you want to look at it. Lots of other clips. You have hip hues, other things. You also have a pretty awesome Tiger King meme that I created. This is original. This probably will go viral. So you saw it here first. You got John Marshall here hugging the tiger, which is judicial review. John Marshall loves judicial review. And that judicial review comes out of Marbury v. Madison. So there you go. All right, next case, McCulloch v. Maryland, 1819. This case was about the National Bank of the United States. And in this case, the state of Maryland taxed the National Bank of the United States. So state taxing national bank. Now, most of you are thinking, you can't do that. Well, it wasn't clear at that time. So there's a couple things decided in this case. And this is also John Marshall, Chief Justice. So two questions. Is the bank constitutional? Which was obviously a huge debate at the time, if you understand Hamilton, Jefferson, American history back at that time. And then can states tax the national bank? So in the decision, here are the two big points you need to understand. John Marshall says the bank is constitutional, and it's constitutional via the elastic clause, the necessary proper clause found in Article 1, Section 8. So this is the first time the Supreme Court acknowledges implied powers in the Constitution. So very, very important. Bank is constitutional. Second, you have an Article 6 supremacy clause. The federal government is supreme, and states cannot tax entities of the federal government. So states can't tax the federal government. And one of the big quotes from this case, the power to tax is the power to destroy. Just think about it. If we allowed states to tax the federal government and to do things against the federal government today, what would happen, right? So two big things. Bank is constitutional. States cannot tax the federal government. Power to tax is the power to destroy. And again, first time implied powers are acknowledged, necessary and proper clause. So there you go. I did it. I see the countdown now from my Screencastify. I got 20 seconds left. So Marbury v. Madison, judicial review. McCulloch v. Maryland, implied powers, supremacy clause. States can't tax the federal government. Until next time, Marbury, McCulloch, 5 minutes, got it done. Hope you guys are all doing awesome, and we'll talk about some more cases later. Bye-bye.